Welcome! Today, we're breaking down the key elements of the Irrevocable Medicaid Asset Protection Trust. In the next 5 minutes, I'll give you a clear understanding of each main article in this trust document, so you'll know exactly what's covered and why it matters. What is the main purpose of this trust? A Medicaid Asset Protection Trust, MAPT, is a special kind of trust designed to help people qualify for Medicaid benefits, especially for long-term care, without spending down all of their assets. When someone needs long-term care, like a nursing home, Medicare does not pay for these costs and only Medicaid can help cover the costs. However, Medicaid has strict limits on how much you can own in assets, like savings, investments, and property, to qualify. If you have more than these limits, you'll have to pay for care out of pocket until your assets are almost gone. While some people choose to do so, others want to ensure that they retain some of their assets for the benefit of their families. A Medicaid Asset Protection Trust lets you protect some of your assets by placing them in the trust. Once in the trust, those assets no longer count as yours in Medicaid's eyes after a certain period, usually 5 years before applying for Medicaid. That way, Medicaid only looks at the assets still in your name, not those in the trust, which helps you qualify for benefits. The benefit of the Medicaid Asset Protection Trust is that while your assets are fully protected, you still have certain rights over them. Let's see how it works. Article 1. Name of trust. This trust is officially named the Your Family Trust. This name will be used for all legal purposes related to the trust, making it easy to identify. Article 2. Reliance by third parties. Third parties, like banks or contractors, frequently don't need the whole trust document to verify its existence or specific details. A simplified affidavit signed by the trustee will work to confirm the trust's authority. Article 3. Use of terms. This article explains specific words, like child or family, to ensure clarity. It also states that the term trustee applies to anyone acting as a trustee, regardless of gender or number of trustees. Article 4. Statement of intent. The grantors created this trust to manage assets efficiently and protect them for the beneficiaries. Importantly, they don't intend to use the assets in this trust for personal benefits, ensuring that government benefits, such as Medicaid, do not count the assets in this trust as theirs. Article 5. Trustee succession. If the initial trustee, first trustee, can't continue to serve, for any reason, then second trustee is next in line. The grantors themselves can't act as trustees at any time, to ensure that there is no confusion about who is controlling the assets in the trust. Article 6. Additional property to trust. The trust can accept more property, whether gifted or bequeathed, under the same rules outlined in the trust document. Which means that you, as grantors, can continue adding property to this trust in the future, and it will be managed in exactly the same manner as the initial contribution. Article 7. Irrevocability of trust. The trust is irrevocable, meaning the grantors can't change, revoke, or benefit from it in any way once it's established. This provision is absolutely crucial for Medicaid asset protection purposes. Article 8. Right of beneficiaries to withdraw principal. This article has been intentionally left out of this document because this trust is not created for estate tax planning purposes. Article 9. Dispositive provisions. This section covers how the trust's assets are managed and distributed. This is a very important article, so we are going to spend a bit more time here. Section 9.b explains how the assets in the trust will be handled during the grantors' lifetimes. In 9.b.4, this section explains that the trustee may distribute assets from the trust to the beneficiaries during the grantor's lifetime. Distributions by the trustee to herself as the beneficiary are somewhat limited to prevent self-dealing. This section allows the trust assets to be used for the family during the grantor's lifetime, providing flexibility. In 9.b.5, this section provides for the grantor's asset protection purposes. It outlines that funds are strictly available for beneficiaries and not available to pay for the grantor's obligations. In 9.b.7, very important for most people, these are the grantor's rights to continue the use of their primary residence for the rest of their lives. The grantors continue to be responsible for the upkeep of the property. In 9.b.8, this is also extremely important. This power allows the grantor to change the percentages of distribution, but only amongst the original beneficiaries. This section, as well as the previous one, A. Allow the grantors to retain some continued control over their assets, and B. Ensure that the assets in the trust will receive a step-up in basis upon the grantor's passing, providing considerable capital gains tax savings. Section 9.c explains how the assets in the trust will be handled and distributed after the grantors pass away. Article 10. Distribution to minor beneficiaries. If a beneficiary is under a certain age, the trustee can manage their assets until they reach this age without giving the funds to the beneficiary outright. The trustee can also use funds for the minor's needs, like education or health care. Article 11. Supplementary needs provisions. This trust includes a supplemental needs trust for any disabled beneficiary. Even if there are no disabled beneficiaries now, things may happen in the future. This article ensures anyone who is disabled can still receive a distribution from the trust that won't affect government assistance eligibility, and funds are used to enhance their quality of life. Article 12. Substance abuse provisions. If any beneficiary has a substance abuse issue, this article allows the trustee to withhold distributions until they're in recovery. They can use funds for necessary treatment. Article 13. Trustees' resignation and successor trustees. This article provides for an orderly trustee succession process. A trustee can resign with written notice, and a new trustee can be appointed without needing to look into the actions of previous trustees. Article 14. Trust Protector. The trust protector is needed to oversee the trust's purpose and can make adjustments if needed. They act as a safeguard to ensure the grantor's intentions are followed. They may make small amendments to the trust to ensure that it continues to function as intended in case of unanticipated legal changes. Article 15. Independent trustee. An independent trustee can be appointed to make certain decisions, especially if there's a potential conflict of interest for the regular trustee. Article 16. Retirement accounts. This section ensures that only individual beneficiaries can receive retirement funds and that these funds won't be used to pay the grantor's estate expenses. This section is needed in case some of the beneficiaries listed are charities, as that would shorten the time for required distributions from the trust. Article 17. Life insurance trust provisions. If life insurance policies are added to the trustee manages them according to specific rules, including paying premiums and using the benefits as part of the trust. Article 18. Trustee freedom from bond and court supervision. The trustee doesn't need to post a bond or have court oversight to manage this trust, which simplifies administration. Article 19. Liability of trustee and compensation of trustee. The trustee isn't personally liable for honest mistakes, and they're entitled to reasonable compensation for their work. The trustee can always waive the compensation if they choose to do so. Article 20. Continuation of trustees' powers. The trustee's authority continues until the trust's assets are fully distributed, even if laws change.